Daf Yomi, Daf Yomi, Daf Yomi, Shevuos, page 30, and 38. Lamed of an Aleph. We're starting the 4th chapter. And it's like 34. What's so special about 34? What's 34? It's Daf 30. It's like 3. And then the 4th chapter. Because this is Parshas Bamidbar, and Bamidbar is the 34th Parsha of the Torah. So, Shevuos, page 30. And the Mishnah. Shevuos eidus neheges panoshim v'le menoshim v'choikim v'le mechoivin m'ksherin v'mesulim v'einu neheges al-beruyin ha'id. The oath of testimony is practiced with regard to men, but not with regard to women, with regard to non-relatives of litigants, but not with regard to relatives, with regard to those fit to testify, but not with regard to those unfit to testify, due to a transgression that they performed. And the oath of testimony is practiced only with regard to those fit to testify. Bifnei bezdin, v'shiloi bifnei bezdin, v'piat v'moi b'acherim v'chayovim, ad shichbu b'hen bezdin. Divrei Rabbi Meir. וחכמים אומרים בין מפי עצמוי ובין מפי אחרים אינם חייבים עד שיחפו אין בית דין. The oath of testimony is practiced both in the presence of a court and not in the presence of a court, when the potential witness takes the oath on his own. But if the oath is administered by others and those denying that they witnessed the incident in question neither take an oath nor answer amen to the administered oath, they are not liable until they deny any knowledge of the incident in question in court. This is the statement of Rabbi Meir. And the rabbis say, when one of the witnesses takes the oath on his own, or whether the oath is administered by others, the witnesses are not liable until they deny any knowledge of the incident in question before the litigants in court. And one is liable for the act of taking a false oath with intent, and for an unwitting act of taking a false oath, meaning he is unaware of the liability for taking a false oath, provided that he takes the oath with intent in terms of the testimony, meaning he takes an oath that he has no knowledge of the matter even though he knows that he witnessed the incident. But witnesses are not liable for taking the oath if they were unwitting in terms of the testimony, meaning they believe that they have no knowledge of the matter. And what are they liable for by taking a false oath with intent? They are liable to bring a sliding scale offering. Gemara, that's the Mishnah. Zok the Heilige Gemara, Mino Hani Mili. How do you know these things? Just a little trivia that Mino Hani Mili is Gematria 245, which I think is the Gematria of Adam Kadmon in regular standard Hebrew Gematria, if I'm not mistaken. At any rate, let's continue. In Apash is 268. Albam is 981. How do you know these things? Matan Torah. Yitzias Mitzrayim, Nasa v'Nishma. Mino Hani Mili, Ditanu Rabbana, Nasa v'Nishma. Okay? The Mishnah teaches that the oath of testimony is not practiced with regard to women because they're unfit to testify. The Gemara asks, how do we know this? Minahani mili. From where is this matter that women do not testify derived? The Gemara answers, it is as the sages taught in the Braita. When the verse states, if an unrighteous witness rises up against any man, then the two men shall stand. Deuteronomy 19:16-17. It is with regard to witnesses that the verse is speaking. Apparently men, not women, may testify. It says, "V'amdu shtei ha'anashim." That's interesting, I never knew that. It says that two men will stand. So these witnesses were obviously two men, not women. Ata omer be'edim o eino ela be'ba'alei dinim כשואי ולשאלה הם הריב הרי בעלי דינין אמור המה אני מקיים ועמדו שתי אנשים בעדים הכסף מדבר ואם נפשך לא נאמר כאן שני ונאמר להלן שני מה להלן בעדים אף כאן בעדים. The Braita continues, do you say that it is with regard to witnesses, or perhaps it is only with regard to litigants that the verse is speaking? Right. Yeah, that's what I thought. Now that it mentions that, it's the two people who are fighting, the litigants. When it says between whom the controversy is, Deuteronomy 19:17, litigants are already stated in the verse. How do I realize the meaning of the phrase, then the two men shall stand? Apparently it is with regard to the witnesses that the verse is speaking, and if it is your wish to say that this is not a proof, another proof may be cited. It is stated here the two men, and it is stated there on the basis of two witnesses. Just as there it is with regard to witnesses that the verse speaks, so to here it is with regard to witnesses that the verse speaks. My im nafshecha lomar חיתם המדינה כסב אשר להם הריב הוא לקרוא בלדינים משתאה נאמר כאן שני ונאמר להלן שני מה להלן בעדים אף כאן בעדים. The Gemara asks, what is the meaning of the statement of the Braita, and if it is your wish to say, why is the initial proof inadequate? The Gemara answers that if you would say that from the fact that the verse did not write, then the two men and those between whom the controversy is shall stand, which would indicate that the verse changes its focus from the witnesses to the litigants. Perhaps throughout the entire verse it is with regard to litigants that it is speaking. Therefore, the Tana cites an additional proof. It is stated here the two men, and it is stated there on the basis of two witnesses, just as there it is with regard to witnesses that the verse speaks, so to here it is with regard to witnesses that the verse speaks. Tanya idach yamnu shnei ha'anashim be'edim ha'kasav medaber ata omer be'edim o eino ela ba'alei dinin amart b'chi shnayim ba'in ladin שלושה אין באים לדין ואם נפשך לומר נאמר כאן שני ונאמר להלן שני מה להלן בעדים אף כאן בעדים. It is taught in another Braita when the verse states, then the two men shall stand. It is with regard to witnesses that the verse is speaking. The Braita continues, do you say that it is with regard to witnesses, or perhaps it is only with regard to litigants that the verse is speaking? The Tana asks, did you say that? If the reference is to litigants, why does the verse mention two? Do two people come to court for judgment and three people do not come to court for judgment? And if it is your wish to say that this is not a proof, another proof may be cited. It is stated here the two men, and it is stated there on the basis of two witnesses, just as there it is with regard to witnesses that the verse speaks. So to here it is with regard to witnesses that the verse speaks. Ma yimashach alomah. V'chi tema betov v'nitaba kamishtabah ikra nemar kan shnei v'nemar lahalan shnei. Ma lahalan be'edim kan be'edim. The Gemara asks, what is the meaning of, if it is your wish to say, why is the initial proof inadequate? The Gemara answers, and if you would say that even though there are cases where there are more than two litigants, it is with regard to a plaintiff and a defendant that the verse is speaking. Therefore, the Tana cites an additional proof. It is stated here, the two men, and it is stated there on the basis of two witnesses. Just as there, it is with regard to witnesses that the verse speaks, so to here, it is with regard to witnesses that the verse speaks. Tanya idach, yamdu shnei ha'edim, be'edim ha'katuv medaber. Ata omer be'edim, o eno ela be'balei dinim. Amalt, v'chi nashim ba'in ladin, nashim ein ba'in ladin, אין באות לדין, ואם נפשך להומר, ונאמר כאן שני, ונאמר להלן שני, מה להלן בעדים וכאן בעדים. It is taught in another writer. When the verse states, then the two men shall stand, just with regard to witnesses that the verse is speaking, the writer continues. Do you say that it is with regard to witnesses, or perhaps it is only with regard to litigants that the verse is speaking? The Tana asks, did you say that? If the reference is to litigants, why does the verse mention men? Do men come to court for judgment, but women do not come to court for judgment? And if it is your wish to say that this is not a proof, another proof may be cited. It is stated here, the two men, and it is stated there on the basis of two witnesses, just as there it is with regard to witnesses that the verse speaks, so to here it is with regard to witnesses that the verse speaks. So just a thought occurred to me right now, that if we're saying that women, according to this Mishnah, I don't know if we hold that way or not, but if women can't testify, think about how many crimes are disqualified that go unpunished if only women are witnesses. Let's just say two valid, solid women witnessed a murder. And they would have convicted this guy had they been allowed to, and they were totally legit, from housewives, totally kosher women, nice, whatever, everything that was kosher. Forget nice, forget about that. Sorry, delete. Everything that a kosher witness has to be as a man, but they happen to be women, and they saw a murder. This murderer is going to get away with murder. That's what we're saying. According to this, it's a kasha. Okay, let's continue. And I think that there's no reason to think that this is not an authoritative mission. I think this is it. Anyway, let's continue. And on the basis of two witnesses, okay. All right. Ma imashkalom v'chitem isha lav oche mishum kol gevud debas melech benima. The Gemara asks, what is the meaning of, and if it is your wish to say, why is the initial proof inadequate? The Gemara answers that it means, and if you would say that with regard to a woman, it is not typical conduct for her to appear in court due to the verse that is stated with regard to women, all the glory of the king's daughter is within. Psalms 45:14. And that is why the verse addressed a situation that is prevalent, meaning a case where the litigants are men and there is no proof that women are unfit for testimony. Therefore, the Tana cites additional proof. It is stated here that two men, and it is stated there on the basis of two witnesses. Just as there is with regard to witnesses that the verse speaks, so to here is with regard to witnesses that the verse speaks. Okay? Tanu Abanan. V'yamdu shnei ha'anashim mitzvah lebalei dinin sheyamdu. אמר רבי יהודה, שמעתי שאם רצו להושיב את שניהם מושיבים. איזה הוא אסור שלא יהיה אחד עומד ואחד יושב, אחד מדבר כל צורכו ואחד אומר לו קצר דבריך. The Gemara cites another interpretation of the verse. The sages taught, then the two men shall stand. This indicates that there is a mitzvah for litigants to stand during the court proceedings. Rabbi Yehuda said, I heard that if the judges wish to seat both litigants, they may seat them. What then is prohibited for the judges? They must ensure that there will not be a situation where one litigant is standing and one is sitting, or a situation where one litigant says everything that he needs to say to present his case, and one litigant, the judge has to curtail your statement. One talks too much, as they say. One just says, what you need to say, the other one's just going on and on. Tanu Rabbanan, בצדק תשפוט עמיתך, שלא יהיה אחד יושב ואחד עומד, אחד מדבר כל צורך ואחד אומר לו, קצר דבריך, דבריך בצדק תשפוט עמיתך, המדון את חברו לקרב זכות. The sages taught, the verse states, but in righteousness shall you judge your colleague, Leviticus 19:15, from which it is derived. The court must ensure that there will not be a situation where one litigant is sitting and one litigant is standing, or a situation where one litigant says everything that he needs to say to present his case, and one litigant, the judge says to him, curtail your statement. Alternatively, it is derived from the verse, but in righteousness shall you judge your colleague, that you should judge another favorably and seek to find justification for his actions, even if, when interpreted differently, his actions could be judged unfavorably. Tani Rabbi Yosef. Rabbi Yosef teaches, בצדק תשמע לבניך, אם שיתחמתו למצוות, ישתדל לנונו יפה. Rabbi Yosef teaches that, from the verse, but in righteousness shall you judge your colleague, it is derived with regard to one who is with you, im sheitcha, in observance of Torah and mitzvos, try to judge him favorably in a manner that the Gemara will now explain. Rav Ula bered Rav Ilai hamiledi nakamed Rav Nachman. Shalach le Rav Yosef ula chaveirenu amis b'Torah v'mitzvos. Amar lemai shalach li lechanofere. The Gemara relates. Story time. Now the Gemara relates. Rav Ula, son of Eli, had a trial pending for Rav Nachman. Yosef sent a message to Rav Nachman. Ula, our friend, is a colleague in Torah and mitzvot, with regard to whom the verse states you should judge him favorably. Rav Nachman said, for what purpose did he send this message to me? Does he expect me to grant him preferential treatment? Every judgment must be undertaken with righteousness. Rav Nachman then said, Rav Yosef sent me the message to ensure I would open with Rav Ula's dispute in the event that other cases come before me for judgment in deference to the Torah, because he is a Torah scholar. And now we're moving on to page 30b, Lamed Amud Bet, with the words Inami Leshuda Dayane. Alternatively, Rav Yosef informed me that Rav Ula is a Torah scholar with regard to circumstances where the ruling is not clear-cut, and the decision is rendered based on the discretion of the judges. That is, when the court is unable to rule solely based on the testimony presented in court and the judges arrive at a ruling based on their sense of the matter. Rav Yosef informed Rav Nachman that if the case is decided based on judicial discretion, Rav Ula is worthy of having the decision ruled in his favor. Amar Ula machloikes b'balei dinin, aval be'edim divrei hakol ba'amida. Dichtiv, v'amdu shnei ha'anashim Amar Huna Machloikis Bishas Maaser Matan. Al Bishas Gemar Din Divrei Hakol Dayanim Bishivo Ubalei Din Ramido Yichsiv V'yoshev Moshe Lishpoit Esau V'yamoit Ha'om. Ula says the dispute between the rabbis and Yehuda with regard to the obligation to stand in court is only with regard to the litigants. But with regard to the witnesses, everyone agrees that they testify while standing. As it is written, then the two men shall stand. Deuteronomy 19:17, Yehuda says, the dispute whether the litigants are required to stand is only at the time of the deliberation. But at the time of the verdict, everyone agrees that the judges issued the verdict while sitting, and the litigants received the verdict while standing, as it is written. And Moses sat to judge the people, and the people stood. Exodus 18:13. Lishnach nena machloikis b'shas masomatan al b'shas k'mal din divrei kol dayonim yeshivo u'balei dinim be'amido deo edim k'mal din namu u'chetiv behu ve'amdu shnei ha'anashim. The Gemara presents an alternative version of the statement of Rav Huna. The dispute whether the litigants are required to stand is only at the time of the deliberation. At the time of the verdict, everyone agrees that the judges issue the verdict while sitting, and the litigants receive the verdict while standing. As concerning the witnesses, the status of the stage of their testimony is like that of the stage of the verdict, and it is written concerning them, the two men shall stand. Dvarim omdim Debetu derav Huna Haviladina kamen Rav Nachman Amar Hechina V'adiyekom Mekame Mistatman Tanateh Debadina Tlakum Mikama Eshet Chaver Harehu Kechaver Amar Le Lishma'e Tse V'yafrach Alai Bar Avaza Ushidi Alvaye Ve'akum. The Gemara relates the wife of Rav Huna had a trial pending before Rav Nachman. Rav Nachman said, "What should we do? If I will arise before her in deference to her status as the wife of a Torah scholar, the claims of the other litigant will be suppressed, as it will be mistaken as a display of preference for the wife of Rav Huna, since not everyone is aware that one is required to show deference to the wife of a Torah scholar. If I will not arise before her, that would run counter to the principle that in terms of deference, the status of the wife of a chaver is like that of a chaver, which means a Talmid Chacham, who is devoted to the meticulous observance of mitzvot." Rav Nachman said to his attendant, "Go outside and cause a duck to fly and cast it onto me, and in that way I will be forced to arise in a manner that will fulfill the obligation to rise without intimidating the other litigant." Nice. Very clever. V'amar mar machloikis b'shas ma'aso matan al b'shas k'mal din divrei kol dayonim yeshivo balei dinim be'amido yosef ma'an d'shar b'sadeh amar ish ploini atazaka ish ploini atachaya. The Gemara asks, but doesn't the master of Huda say the dispute between Yehuda and the rabbis whether the litigants are required to stand is only at the time of the deliberation, but at the time of the verdict? Everyone agrees that the judge issues the verdict while sitting, and the litigants receive the verdict while standing. How then can Rav Nachman arise? The Gemara responds, one may fulfill both requirements in a case where he sits like one and one ties his shoe, neither completely standing nor completely sitting, and says his verdict. So and so, you're innocent, and so you are guilty. Amar Rabba Rav Huna Hai Tzova V'Mirabanan Lemaret Titluhu Dina Mahadeh Dadi Mutvina Le Tzova Mirabanan Ulemaret Nam Yamrin Le Tiv V'Ikae Let Lag Ba. Rabba Bar Rav Huna says, in this situation where a Torah scholar, which is the Tzurva Mirabanan, Tzurva Merabanan, and in Am Haaretz have a court case one with another. We see the Torah scholar, and to the Am Haaretz we also say sit. And if he chooses to stand due to deference, we have no problem with it. Rav bar Sharavia Haveledi Nakame de Rav Papa. Otve Otif Nami Baal Dina Dine Ata Shlich al Medina Betash Bediok Ben Amaaretz Pero Amar le Rav Papa Tiv Hechi Avid Hache Habistatman Tanite Amarav Papa Mema Amar Ihu Ha Otvan Shlichahu the Gemara relates, Rav bar Sherevia had a trial pending before Rav Papa. Rav Papa seated him and also seated his litigant counterpart, who was in Am Haaretz. The agent of the court came and kicked and stood the Am Haaretz on his feet to show deference to Torah scholars there. Rav Papa did not say to him, sit. And Rav Papa did not say to him, sit. The Gemara asked, how did Rav Papa act in that manner by not instructing the Am Haaretz to sit again? But aren't the claims of the Am Haaretz suppressed by Rav Papa's perceived preferential treatment of Rav bar Sherevia? The Gemara responds, Rav Papa said to himself that the litigant... Wait, I don't understand what's going on here. Let's go again. The Gemara relates that Rav bar Sherevia had a trial pending before Rav Papa. Rav Papa seated him and also seated his litigant counterpart, who was Am Haaretz. The agent of the court came and kicked and stood him. He kicked him. He said, stand up. Pah! I mean, not kicked him. He kicked his feet or something. And stood them up on his feet. And to show deference to Torah scholars, and Rav Papa did not say to him, sit. The Gemara asked, how did Rav Papa act in that manner by not instructing the Am Haaretz to sit again? But aren't the claims of Am Haaretz suppressed by Rav Papa's perceived preferential treatment of Rav bar Sherevia? The Gemara responds, Rav Papa said to himself that the litigant will not perceive bias, as he says, the judge seated me, it is the agent of the court who displeased me and compelled me to stand. Okay, I'm not sure what's going on there, but whatever. Maybe you guys did. Okay. Right. Weiter, where will we? Okay. V'omar Rabba bar Rav Huna, Hai Sofer Balan, Yad Besaduta, Bezir Bamir Talmet Lebedina, Tizu Tarmine Leasadai Kame Velo Azil, Amar Rav Shisha Bred Rabidi, Amar Adan, Af Adan Nami Tanina. Matzo sak o kupa, bein darko litor, harezeh lo ito. And Rabba bar Rav Huna says, in the case of a certain Torah scholar who knows testimony relevant to a certain individual, but it is a demeaning matter for him to go to the court consisting of a judge who is less prominent than he, in order to testify before him, let him go and testify. Rav Shisha, son of Hidi, said, we learn that halacha in the Mishnah, but Messiah 29b as well. If one found a sack or a basket, and it is not his typical manner to take it, he shall not take it in order to return it to its owner. Evidently, a Torah scholar may refrain from performing the mitzvah to return a lost item. See Deuteronomy 22, 1-3, if it is not in keeping with his nature. Hani mili b'memona, aber b'isura ein chachma v'ein tevuna v'ein yitzar neged Hashem. Kol makom sheyesh bo chilu Hashem, ein cholkin kavod larav. The Gemara notes, this matter applies only with regard to cases involving monetary matters, but in cases involving ritual matters, the dignity of the Torah scholar is not a consideration, as it is written. There is neither wisdom nor understanding nor counsel against the Lord, Proverbs 21:30, from which it is derived. Wherever there is a desecration of the name of the Lord, one does not show deference to the teacher. Rather, the Torah scholar forgoes the honor due him in order to avoid violation of any prohibition that would desecrate the name of God. Rav Yeimar Haviyad Lebis Besadu Zelmar Zutra Os Lekavane Memar Os Vinu Likulehu Amale Ramashi Amemar Behamar Ula Machloikis Bebali Dini Aval Beidin Divrei Kol Beamida Amale Hai Aseh Hai Aseh Aseh Kavod Torah. The Gemara relates, Rav Yeimar knew testimony relevant to the case of Mar Zutra. He came before a Maimar who seated all the witnesses in deference to Rav Yeimar. Rav said to a Maimar, but doesn't Ula say that the dispute between the rabbis and Rav Yehuda with regard to the obligation to stand in court is only with regard to litigants? With regard to the witnesses, everyone agrees that they testify while standing. And Maimar said to him, this, meaning witnesses standing during testimony, is a positive mitzvah. And that, meaning treating Torah scholars with deference and allowing Rav Yeimar to sit, is a positive mitzvah. And the positive mitzvah of deference to the Torah takes precedence. A Maimar seated Rav Yeimar in deference to the Torah. In order to prevent a miscarriage of justice, he seated all the witnesses. Siman is Sane Gaon, Bul, Gezelat, and Mirma. The Gemara provides a mnemonic for the ensuing discussion: advocacy, ignoramus, robbery, and fraud. I guess these are the next 4 different topics, I think. Tanu Rabbanan Minayin l'dayanin shelo yaseh sinigro l'dvarav tam lomar midvar sheker tirchach. Minayin l'dayanin shelo yishev tamid bur lifanav tam lomar midvar sheker tirchach. The sages taught, from where is it derived, that a judge should not engage in advocacy for his own statements and devise various pretexts to justify his erroneous rulings. It is derived, as the verse states, distance yourself from a false matter, Exodus 23, verse 7. And from where is it derived with regard to a judge that a student who is an ignoramus should not sit before him to discuss the proceedings? It is derived, as the verse states, distance yourself from a false matter. When an ignorant student engages in the proceedings, he is apt to cause the judge to err in judgment. Minayin l'dayanin sheyodeh lechavero shehu gazlan וכן, עד שיודע בחברו שהוא גזלן, מניין שלא יצטרף עמו, תמה לומר, מדבר שקר תרחק. From where is it derived that a judge who knows that another judge is a robber and is disqualified from serving as a judge? And likewise, a witness who knows that another witness is a robber and is disqualified from serving as a witness, from where is it derived that he should not join him in judgment or testimony? It is derived, as the verse states, distance yourself from false matter. Minayin l'dayan sheyodeh b'din shehu miruma shelo yomar ho yireh d'midin echetchenu v'yehem. From where is it derived that in a case where a judge who knows that the witnesses testifying before him are lying, even though he is unable to prove it through their cross-examination, and with regard to the verdict, the result will be that it is fraudulent, that he should not say, since the witnesses are testifying, and I cannot prove their deceit, I will decide the case based on the testimony, and I guess I'll see the rest of the next daf. God willing.